State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney, appearing for the state. Mr. Robinson, are you here?
I am here representing the name, ma'am.
Welcome to today's breakdown, where courtroom reality collides with internet fantasy. Today we're diving into the state of Kansas versus Tremaine J. Robinson, a sovereign citizen who believes the laws of Kansas don't apply to him. Now here's the thing. When you walk into Judge Webster's courtroom armed with pseudo-legal jargon from YouTube forums, you're not just outgunned, you're practically volunteering for a legal demolition. The prosecutor? Relentless. The judge? No nonsense. And our defendant? Well, let's just say he's about to learn the hard way that special appearance means nothing if you're not a licensed attorney. Buckle up, because this case is packed with drama, failed strategies, and more gotcha moments than a reality show reunion. And trust me, you won't want to miss the ending.
And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right. Anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime. If there's no one that I've...
Here's where things get especially frustrating. The defendant insists that because no one was physically harmed, his speeding charge is invalid, a so-called victimless crime. But this logic misses the entire purpose of traffic laws. The state doesn't need a bloodied victim in the courtroom to justify speed enforcement. The law itself is preventative, designed to stop tragedy before it unfolds. Imagine everyone driving at whatever speed feels right to them. That's not freedom, that's chaos waiting to happen. The state of Kansas is the victim here because laws were broken, and those laws exist to protect everyone on the road, including him.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I stated, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, it would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appear to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office, so there is.
And here we go, the Sovereign Citizen's Greatest Hits album. 7 pages packed with recycled internet arguments. Gold fringe flags, admiralty law, right to travel theories, jurisdictional loopholes, and every buzzword you've ever seen in a beat your ticket forum. The problem? None of it carries any actual weight in court. Judges across the country have read these word for word 100 times. And while defendants think they're unveiling some hidden legal truth, to the court it's like deja vu, just another attempt to gum up the process with meaningless paperwork. It's like showing up to a chess match with Uno cards.
Subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court, administrative law in the next paragraph. Ministerial offices being incompetent to receive grants of judicial power from legislature, citing a case, looks like 140 California 1, stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear, talking again about an administrative agency, and tribunals. Judicial tribunals, alleged personal jurisdiction of the defendant is void. The court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, J.
Notice Judge Webster's calm, almost unfazed demeanor. She doesn't raise her voice. She doesn't argue. She simply acknowledges the filing for what it is, empty legal theater. That's the real difference between sovereign citizens and seasoned judges. Defendants often expect drama, some kind of back and forth where they'll trap the system in its own contradictions. But instead, the court just shrugs and moves forward unimpressed. That silence? It's devastating. It's the legal equivalent of rolling your eyes at a magician who forgot his rabbit. No drama, no debate, just a reminder that the law isn't a performance, it's procedure.
Next page talks about a legislative act of constitutionality, substantial harm, right to a trial by jury, all power inherent in the people, legislative assembly. Officer Collins K. issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed, end quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed, any documents pertaining to the training certification, disciplinary reports of the trooper, tuning fork calibration records, certification records for the device, more information about calibration records, device records. He says the information requested directly relates to reliability an accuracy of evidence against him. So he's wanting proof provided within 21 days, or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure. Under 28 USC 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America, executed July 26, 2023. Again, signature, and then in brackets, Robinson, Tremaine, J, without prejudice. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves or are considered sovereign citizens.
Did you catch that? The defendant admitted he only served his discovery motion yesterday, the day before trial. Imagine mailing your wedding invitations the morning of the ceremony and expecting a full guest list to show up. That's how absurd this is. Courts run on deadlines for a reason. Evidence requests, witness lists, motions. All of it has to be filed in advance, so the system works fairly. By serving late, he essentially sabotaged his own defense. And now, the court has every right to deny it, which leaves him standing there empty-handed, still convinced he's been wronged.
Revocation of signatures on the final page 7, mentioning that, quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road in the state of Kansas by Officer Collins K., March 27, 23, and then signature authorized representative and attorney in fact. So after that document was filed pro se, apparently, by the defendant, Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se, and that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se, so Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
This is where the gulf between real law and sovereign fiction becomes painfully clear. The prosecutor doesn't waste breath arguing feelings. He cites case law, actual, binding precedent from the Kansas Court of Appeals and beyond. And what do those rulings say? Over and over, courts have called sovereign citizen claims frivolous, meritless, and utterly invalid. That's the crushing blow here. It's not the prosecutor's opinion. It's the judiciary's repeated stance across decades of rulings. When you walk into court with fringe theories, you're not introducing new ideas. You're recycling arguments that have been legally dead for years.
Document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a.
We're going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order or you could be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive need statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case involved a sovereign citizen where the court noted in the memorandum opinion.
Objection hearsay. Objection hearsay.
Case law is not considered hearsay or.
I'm not a